All right, good morning. This is the motion call for C407. I'm Judge Stacy Seneczko, and court is now in session. Please note that no audio or video recording of this proceeding or its live stream is permitted. Violation of this instruction is the basis for a finding of contempt of court. Please keep yourself muted until your case is called. If you need to leave to go to another courtroom, you may advise my clerk by using the chat function. You may not send me any chat messages. All orders from today must be emailed to my clerk at the email address for this courtroom, which is cc407@lakecountyil.gov. That address is also in our administrative order, which is online, but again, that's cc407@lakecountyil.gov. The order must indicate who is present in court today, and it should also indicate the attorney's name and ARDC number. The order should be forwarded to opposing counsel to make sure you're in agreement with the order, just like you would if you were in court, and then emailed to that address by 1 p.m. today. It should be in Microsoft Word format, and all counsel of record copied on the email when you send that order in. If there are any agreed orders, I will call those first. You can raise your hand to let me know that you're ready. You can do that old-fashioned way, or you can raise your hand by clicking on the participants tab at the bottom of your screen, then click on your name and raise hand. When called, unmute yourself, state your name, your case number, and the party you represent. Do we have any agreed orders this morning? Do I see anyone? Oh, here we got someone. So Mr. Kirk, or Irk, where are you on here? There you are.
Good morning, Your Honor. Defendant pro se John Rizzo might be on the call too. I know he was in mine as well.
Yes, I am present, Your Honor.
Good morning.
Good morning.
So this is 18 CH 1251, is that right?
That's
Yes.
correct.
Your Honor, it's up for judgment. We're moving to continue it to August 21st, 2020 at 9 a.m. We had sent a proposed order in Word. I will resend one with the information you requested at the beginning of the call. Mr. Rizzo and I had been texting. I believe we're in an agreement. Is the court available that day at that time?
Yes, for the August 21st date.
Yes, Your Honor.
That's an agreed date if it's good with the court.
It is, thank you. So you'll just submit a new order then?
Yes, Your Honor.
Okay, is there anything else we need to discuss?
No, Your Honor.
All right.
Nothing. Thank you.
Thank you.
Thank you, Your Honor. Have a nice day.
Thanks, you too. Any other agreed orders? All right, Mr. Quinn. You're muted.
There we go. Can you hear me now?
I can. Yes.
Okay. Judge, this is case 20CH125. I don't see Mr. Thutt here. I think it's up for some kind of status, but we have an agreed briefing schedule on a motion for judgment on the pleadings, which is set for July 10th, 2020. So
Okay.
I would suggest we put everything, whatever this was up over till that day.
All right. I think it was just a status date. So if you could just submit an order saying it was up for status and that the 7/10 hearing date stands.
Yes, and also, Judge, there is a June 26th date for hearing on motion, but that was actually crossed off the order that we submitted, and the real date is July 10th. So on the clerk's site, we have a June 26th date. Can I strike that also?
Yes.
Great, Judge. I'll prepare that order and get it over to you.
All right. Thank you.
Thank you. Bye now.
Goodbye. Are there any other agreed orders? Let's see. Mr. Morrison.
Thank you, Judge. Mr. Harrod is on the call too. This is 16 CH 1166 and 1167. This is up on my client's motion to disqualify Mr. Harrod as attorney. It hasn't been briefed yet. We've been trying to settle the case. We haven't settled it yet, so I believe Mr. Harrod is just asking for a new briefing schedule and a hearing date on our motion.
That's correct, Your Honor. We've had some substantive settlement conversations. We actually met in person right before the shutdown, and it took a while to exchange some information, but we've had some talks in the past week. This would be the last extension we would request.
All right, so have you talked about a briefing schedule that might work for you both?
28-14 is fine with me.
Okay, that's fine.
All right, so. Have the courtesy copies to me by the 27th of July, and we can have the hearing on August 7th. Does that work?
Yes, Your Honor.
All right.
Yes,
and
it
then-
does, Judge.
Hold on 1 second. I want to check the time. Linda, do you know how many cases I have up? August 7th.
There's only one on your call.
Okay, why don't we do 9:30?
Okay.
You got it. Mr. Harrod, I'll draft the order and get it to the court and get your copy.
Thank you, Mr. Morrison.
All right, very good.
Thank you, Judge.
You're
Thank you.
welcome. Any other agreed orders? Oh, it looks like Pentaga, 19CH, I'm sure I'm mispronouncing your name, but 19CH 1110, is that right?
Correct, Your Honor, and it's Ann Pantoga. You did pronounce it correctly.
Oh, look at that.
Representing defendant Citibank on the GW Nietzsche Inc. versus Harold Kaplan in Citibank.
Thank you.
And I believe Mr. Kaplan is also here.
Yes, I am, Your Honor.
Oh, there you are. Good morning.
Judge, the
Morning.
plaintiff's attorney sent us an email at 7:30 this morning. She had a death in her immediate family that she was just notified this morning, so plaintiff will not be here. But we, if you recall, we are working on settlement for count 1, the mechanics lien count. And I believe as of yesterday, we have a finalized settlement agreement that still needs to be signed. There's been some issues with, we had to have an insurance check reissued, so this has taken a little bit more time than expected. But we're in agreement, if it works for the court, to continue this matter for status of settlement to July 17th at 9 a.m.
What about the other counts? Are we,
Those are still pending. And my client's not involved in the other counts, but those are still pending.
okay,
Yeah, Your Honor, also with the settlement, part of the settlement is an amendment to those, to the rest of the complaint. So that I think the complaint would have to be revised somewhat, then get to the answer.
okay. Do you know how many cases I have up, Linda?
17
July.
and 8 or 6.
Okay, that would be
One
fine.
of 10.
Okay, Judge, we'll get an order to your email address
right.
circulated today.
All right,
before
thank
one.
you. Thank you very
Thank
much.
Okay, thank you, Your Honor.
And then I see Ms. Gatone. I can't read the case you're here on, but Wendy Coletta Gatone? Where'd you talk to? You have an agreed order? I can't hear her. Are there any other agreed orders? All right, so I'll go down the call. Giabrone versus Podrosky. And I'm sure I'm mispronouncing that. Also 20CH111.
Yes, Judge. Rocky Hudson on behalf of the defendants.
All right, are you expecting,
I just got an email from opposing counsel. He says he's in the holding zone. I don't
oh,
know.
he's in the waiting room?
That's what he said, but I don't see him in the gallery.
I don't see anyone in our waiting room. I'll pass it. You might want to email him, make sure he's in the right courtroom.
Will do.
All right, thank you.
Thank you.
Village of Fox Lake versus Chicago Title, 20CH314. Oh,
Yes, Your Honor, Mallory Maluzzi on behalf of the village.
all right.
And I don't believe anyone has filed an appearance on behalf of either defendant. We do have service on Lake County Housing Authority. We are waiting still for the Cook County Sheriff to get back to us on status of service for the Chicago Trust account. They haven't sent back either their inability to serve or affidavit of service yet. So once we get an update from them, we'll either be proceeding with the case or filing a motion for alias summons or a special process server in order to get that served.
All right, so how far do you want to go out?
I'd like to go just July 17th, just so we should have an update on that. And if I need to file a motion before that, I will, but.
All right, that's fine. All right, anything else?
No, that's it, 9 o'clock as well. Is that this?
Yes,
Okay,
fine.
then I will,
You'll
I'll submit an order.
Okay,
Thank you.
all right. Keith Security Systems, 19 CH 424. Westberg versus Barcroft, 19 CH 535. All right, so Mr. Nazarian.
Morning, Your Honor. Ken Nazarian for defendant Susan Barcroft. I believe we're up here on plaintiff's motion for alternative service, but I haven't heard anything from them. I can tell the court that we've filed our answer to the complaint per the last order, and we've answered plaintiff's written discovery.
Okay.
So we're moving forward with the case, but I know they were trying to get alternative service, but I have no I have no skin in that game, really.
Sure. Well, I'm going to pass it for the purposes of that motion. All
That's
right?
fine.
Looks like we have somebody in the waiting room. Okay. All right. George Street Acquisitions, 19 CH 626.
Yes, Your Honor. Carrie Conlon for the defendants.
Good morning.
Morning, Your Honor.
Is anyone here on behalf of the plaintiff?
I believe so, Mr. James Stothna.
Do you see him?
I don't see him, but he did email me earlier that he was getting on the call, so.
Unless he's one of these folks that are muted. We have 3 people in attendance that are muted. Yeah. I will unmute each of them. All right, is anyone else here on George Street Acquisitions? 19 CH 626? I'll pass it then. It sounds
Okay.
like you show up. All right. American Demolition, 19 CH 1368.
Mike Lacey's here on behalf of the defendants, Fountain Square and Next Gen Hotel.
All right, is there anyone else on 19 CH 1368?
Yes, Your Honor. This is Brad Staubis on behalf of defendant Klein Construction.
Mike Lacey on behalf of Fountain Square and Next Gen Hotels.
All right. And so it looks like it's defendant's motion to vacate an extension of time. Is that right?
Yes, Your Honor. Klein Construction, there was a default entered. We filed a timely motion to vacate. I did speak to, just for a quick status, I did speak to plaintiff's counsel yesterday. I'm not sure if she's on or not, but we had talked about settlement, and I sent her over a settlement proposal yesterday. So what we had anticipated doing this morning, if it's okay with Your Honor, is vacating any defaults against Klein Construction and then continuing it for 30 days to hopefully just enter into a settlement agreement and then dismiss the case, Your Honor.
Would it dismiss the case in its entirety?
Yes, it would, Your Honor. This is a construction case. Klein Construction was the general contractor. American Demolition was a subcontractor, and I believe the other defendant on the phone is the owner. So they would be, the entire case would be dismissed. Yes, Your Honor.
All right, and then Is there any objection, do we know, to defendant Nexon Hotel in Fountain Square's motion?
Your Honor, this is Lauren Rankins on behalf of American Demolition, the plaintiff.
Oh, good.
At this time, Mr. Staubus is correct. We have talked settlement, and assuming that we can get settlement, I think that'll resolve all of the issues, including the 2 motions to vacate and motion for extension of time that are currently on file. So it's my suggestion, Your Honor, and my request that rather than entering any sort of order with respect to vacating the defaults or otherwise, because we would like to have a chance to respond, especially as it relates to the motion to vacate against the owners. Rather than doing that, we simply continue this matter for 30 or 45 days, if Your Honor allows, in order to continue settlement with the general contractor. We have received some promising settlement terms. I do have a counteroffer to give Klein Construction this morning. I just unfortunately didn't have time to type it. I was trying to figure out Zoom before I sent the email. But I do hope and I do think that we will be able to settle this and get executed settlement agreement within the next 30 to 45 days, really mooting all the rest of the issues.
Okay, so are the defendants agreeable to that proposal?
Yes. Yeah.
All right, so let's look at to a date you might want to come back. You're thinking what, beginning of August maybe? Is that right?
That would work for me, Your Honor.
All right, how about we can do the 7th at 9. Does that work?
That's fine for us, Your Honor.
Okay.
That's fine for the plaintiff, Your Honor.
All right, and then I don't know if everyone was on the line when I gave my introductory instructions, but be sure that the order from today's status and motion is submitted by email tc407@lakecountyil.gov. I ask that you circulate it with the attorneys that were here to make sure that it conforms to the agreement and that all attorneys be copied on the email when it's submitted. Okay?
Okay, thank you, Your Honor.
You're welcome.
Thank you.
And I apologize, that's August 7th, is at 9 o'clock?
Yes.
Okay, thank you very much, Your Honor.
Thank you. All right. Safeco Insurance versus Johnson.
Good morning, Your Honor. Jenna D. John on behalf of Safeco Insurance.
Good morning.
We have not effectuated service yet, so I'm not expecting anybody. This is our initial status. This is a declaratory judgment action Safeco filed with respect to insurance coverage for an underlying case. The underlying case has settled. So we expect once that is wrapped up and resolved, we expect to dismiss this DJ as well.
Okay, good. So then what time frame would you expect that we can just set this over for entry for status, and then you can always mail in a dismissal order if it resolves?
Of course. Is 60 days amenable for Your Honor?
That's fine.
So August 12th?
That's fine.
At 9 a.m.?
Yes.
Okay, thank you, Your Honor.
You're welcome. All right, VSD 2016. It's 20CH 258.
Good morning, Your Honor. Kara Houck on behalf of VSD.
Good morning.
Good morning, Your Honor. Bruce Lickstein on behalf of Erie Insurance.
Good morning.
Good morning, Your Honor. Thomas Reed on behalf of the defendant Advocates LLC.
Okay. So it looks like we're here on a plaintiff's motion for partial summary judgment. Is that right?
Yes, that is correct, Your Honor. And defendant has also filed a motion for summary judgment. So we're essentially here on cross motions for summary judgment.
Okay.
I suppose we can just set a briefing schedule and a hearing date.
All right. Have you talked about what type of a briefing schedule might work?
I didn't. I was just looking at dates, and if it's okay with defense counsel, I was thinking maybe July 10th for the respective responses, and then 14 days after that, July 24th for the replies. Is that okay with you, counsel?
Yeah, give me that reply date again, Kara.
Would be July 10th for responses, July 24th for replies.
That's fine. And I'll just note, we were just trying to, I know you wanted to get things going. So we just filed along with our own motion. We also filed a response, it was yesterday or the day before, to your motion. So,
Okay.
but that's fine, but the parallel scheduling is fine. But you'll already have our response when you open all our documents.
All right, and so,
Well, if that's the case, knowing that I prefer to move this case along, I could just take 14 days to file a reply to your response. And if you want to set your own briefing schedule, that's fine too. So I can file my.
You're going to respond. Well, I think what we want to do is I like your idea of parallel, keeping everything on the same page, and then you end up with one hearing date for the two motions.
let's just do
That's
it.
what I'm suggesting.
Yes, let's just do it as initially proposed. All
Okay.
right. And so then the last brief, if I understand you correctly, would be July 24th, did you say?
Correct. Yes.
All right. So have the courtesies to me by July 27th. And we can go ahead and set it for hearing on August 7th at 10 o'clock.
All right. We also have a date on your calendar for 6/19, which I'll put in the order that we're striking that date.
Okay, very good.
There's a second date as well. There's the 19th.
Okay.
And there's also a status date of 7/10, which
Okay.
I'm suggesting be stricken.
Right, yeah. Is that okay with you?
Yeah.
Okay.
If you're asking me, yes.
All right, I'll strike those two. I am, Your Honor.
All right.
I'm sorry, Your Honor, I was fiddling around with the firm calendar here. I missed, what is the hearing date you were giving us?
August 7th at 10 a.m.
Okay,
Also, I'll send you an order.
yeah, and then Bruce, are you on this?
Yes, sir.
Okay, yeah, hi, Tom Reed. We did get the third-party complaint served. I'm not sure the date of service. I think it was relatively early in May. So the insurance company is in the case now. I don't think there's any, you don't have a response yet or any pending motions, as I understand it. Is that correct, Bruce?
We have not answered
Okay.
the third-party complaint, and our intention for about the past 3 weeks has been to try to resolve the matter on a global basis, Your Honor. I think that counsel for the plaintiff and I have had some very substantive discussions, and we've moved forward in that on that settlement issue, I think in some material ways. I would like to speak to the plaintiff's counsel later today, and I will contact her. I wanted to speak to her before the court hearing today, but I just ran out of time. Erie is going to try to take care of everything globally that we hope resolves all the issues. There are a couple of remaining questions that could exist after we pay for the damages, and those are the issues that we're going to try to figure out to see if we can resolve this case.
All right, do you have an appearance on file?
Your Honor, I don't believe that we have filed our appearance yet, but if we haven't, I apologize, and we'll get it on file before the end of the day.
Okay, and then hopefully you'll be able to resolve it and it'll take care of everything, but why don't we have a time frame for you to file a responsive pleading then? I mean,
That's fine.
have plenty of time if you think it's going to settle, but otherwise,
Sure.
you want to kind of move it along.
Absolutely, Your Honor.
So how long do you do
Can
that?
we have 30 days?
That's fine. And then on the 7th, August 7th, which is the hearing date, we'll also do it for a status of pleadings. Okay?
Very
Which
good,
will
Your
take
Honor.
management. Hopefully I'll receive a dismissal order prior to then.
That would be good.
Yes, it will.
We'll do our best to settle, Your Honor.
Right, very good. Anything else?
No,
Okay.
thank you.
You're welcome.
Thank you,
All right.
Judge.
Thank you, Your Honor.
You're welcome. Giabrone versus Podrasky. Mr. Hudson, did you find your opposing counsel on that?
Yes, Judge, I'm on the phone with him now, trying to get him to connect.
Okay,
Your Honor, can you hear me?
I can hear somebody. Yes.
Judge, this is Tom Burney. How are you? I'm sorry, I had
All right.
technical difficulties.
How are you?
Okay, I'm a little stressed out trying to join you, but I'm here now, so. Mr. Hudson's, this is a case we're looking for information from our neighbor who's the dominant estate. It involves flooding issues. We're the servient estate. We've been suffering a lot of flooding. We asked the gentleman's client to grant us access. They refused. We brought this action so that we could find out whether or not there is, if the cause of the flooding is from the dominant estate. In the meantime, there was a contract with KHOP to sell the ground to them. That contract has been terminated. KHOP's pulled out of the Midwest, or at least out of Illinois. So they have filed a motion to dismiss. What we have is, we had alleged that there was a contract. We now don't have a contract. There is no contract. And so question is, do they want to modify their motion to dismiss as a result of that important changed fact, or do they want to proceed? If they will accept the fact that it is a fact that they've terminated, then we could go to an argument on it, but a key part of their argument has been eliminated in my mind. Thank you, Your Honor.
Judge Rocky Hudson, on behalf of the defendants, there's actually 4 motions up. There's a motion to vacate technical defaults, which me and opposing counsel have agreed to. That's the reason why I filed my 2615. We agreed that I will be able to answer, otherwise plead. So we're going to ask the court to grant that motion. We did file a 2615 motion. I think our arguments are still relevant, and I'm not looking to modify that motion. I did agree to a briefing schedule opposing counsel regarding that motion. And then we have 2 other motions, and it deals with a motion to quash subpoenas that opposing counsel issued against the Village of Wakanda, and also K. Hovian, which I believe goes beyond the scope of our litigation. We've agreed to a briefing schedule on those motions as well. The only issue, and I did provide opposing counsel a proposed order, the only issue was, while the motions to quash are pending and the judge and Your Honor hasn't determined the results of those motions, I asked opposing counsel, 1, to, if he receives any responses, not to open up those responses until Your Honor makes a ruling, and 2, to notify the K. Hovian and Village of Wakanda that they're not to respond to the subpoenas until Your Honor makes a ruling on those pending motions to compel, motions to quash. Opposing counsel takes a position that he doesn't have to do that and he doesn't want to do that. And that's the only 2 issues that are really before Your Honor today, because we have an agreement on all the other issues as far as a briefing schedule.
Your Honor, counsel's correct in his representation about our agreement on portions of the order. In our mind, if we can get the information that we've requested, it may not be necessary to go onto their property, which they've characterized as intrusive. All we want to do is bring wetlands experts and stormwater management experts and people who do drain tile to see what's happening from the dominant estate as it flows onto our ground. So that's why we'd be opposed to that. If Your Honor is going to rule that we cannot look at any of those documents until you've ruled on the motion to dismiss, then we would ask for some order to KHOV and the village to protect those documents. It's especially important with KHOV because they are leaving the state, and I don't want to have to be chasing them. You'd understand that. So that's all I have, Your Honor.
So yeah, I'm not going to, if you have a motion to quash, it seems like we should keep things in status quo. Nothing should change in interim. So I'll grant Mr. Hudson's request that they either be advised by pursuant to this order that they need not comply with the subpoena, but they are to preserve any records that may be responsive to subpoenas. So what you said you had an agreed briefing schedule. What kind of a schedule did you have, and what hearing date would that put us out to?
Yeah, Judge, the last reply date for all the motions is July 6th. So I'm asking for until June 19th to respond to his, I'm sorry, plaintiff's going to respond to all motions by June 19th. We propose to file a reply brief in support of the motions to quash by June 26th, and a reply brief in support of the motion to dismiss by July 6th. So it's one additional week.
All right. Where the hell does July 15th look for you? Would that date work for you, gentlemen?
What date, Judge?
July 15th is the date I'm proposing?
Yes, Your Honor.
All right, let me just check to see if I'm not.
For all at 9.
Okay, let's do this at July 15th at 9:30. And if your last brief, you said is.
Judge, can you just hold on one second? I'm just getting my book. I might have a trial that day. Can you hold on 1 second?
Uh-oh. Going to have to learn the do's and don'ts of Zoom court hearings, Your Honor.
Well, you made it on, so that's a do.
Yes. I was on yesterday's court call. I got bad information, so I'm learning.
Sorry, Judge. July 15th is fine.
All right, July 15th at 9:30, and then have the courtesy copies to me by the 7th.
Yes, Judge.
All right, anything else?
No, Judge.
That's all for me, Your Honor. Thank you.
And
Good
then
day.
submit that order like we talked. I don't know if I don't think Mr. Burney was on, but the order is submitted to the cc407@lakecountyil.gov email box, and it looks like you already had a draft order in place. You'll modify it with the.
I'll modify and I'll get it to opposing counsel.
All right, very good.
Thank you.
You're welcome. All right, Keep Security Systems, 19 CH 424. Westberg versus Barcroft. Did that counsel appear on that yet? All right. You need to unmute yourself.
I don't.
You don't have plaintiff's counsel still?
Not that I can see, Your Honor.
Have you reached out to him?
I have not, but I can.
Can you
Let me see if I can try to get him on the phone.
All right, thank you. Truck Insurance versus Willows, 16 CH 444.
Good morning, Your Honor. Hugo Colella and Jack Pryor for Willows.
Your Honor, Michael Ferran for the Plaintiff Truck Insurance Exchange.
All right.
Your Honor, this is Truck's motion, a couple of motions, an emergency motion to stay the briefing on the Willows motion for summary judgment on June 1st. There was a hearing with the court, and at that time, the court set a briefing schedule, which culminates in a hearing on July 24th of this year for the Willows third motion for summary judgment. We filed the emergency motion to stay briefing on the motion for summary judgment, given the additional materials that were produced by the Willows just prior to the COVID-19 pandemic in late February of this year. Because of those additional materials that were finally produced by the Willows after a number of motions to compel and the Willows' refusal to comply with discovery requests, we obtained new information. That new information is going to require the depositions or redepositions of witnesses. And I would ask the court to suspend the briefing schedule at this point in time. And we have, as part of the court's June 1st order, we have a status hearing for June 24th. I would ask the court to keep that status hearing so that counsel can report on their progress in terms of scheduling the depositions that need to be taken in light of the recent document production by the defendant. And at that point in time, hopefully we'll have deposition dates in place, and we can advise Your Honor on when the summary judgment motion can reasonably be heard, while giving Truck an opportunity to actually obtain the evidence that the defendant had been withholding for so long. In addition, Your Honor, we have a motion to amend our affirmative defenses based on the evidence, the documentary evidence that we did obtain.
Response?
Your Honor, this is Hugo Colella. We were here 11 days ago and we had the same exact argument where Mr. Shukas didn't want to have a briefing schedule based on the same arguments Mr. Ferrand just made, and they were rejected. This is not an emergency. This is an emergency of their own making. That's the first point. The second point is we don't know the documents that they put in front of you, Your Honor, they're not bait stamped. And I'm assuming they're the documents we produced, but we produced documents in the fall of 19. Okay. And then they went through them and then they said, well, you didn't, it wasn't a good enough production. You didn't go through them. And then we were here in January and then we then went through them again. I don't know whether these documents were produced to them that they just gave you, whether they knew about these documents in the fall of 19. But at the very least, if you look at one of these documents, the date at the bottom, the print date is May 4th. May 4th. They talked about redeposing these witnesses in January. They didn't notice anything. They talked about redeposing witnesses on June 1. They haven't noticed anything. And we should proceed with the schedule. If they believe that they have evidence that is relevant and material to the summary judgment motion, or that they need additional evidence, then they should put it in their opposition and we can brief it, because the evidence they provided you is legally immaterial. All right. The undisputed facts are that, and if you don't want me to get into the merits, that's fine, but that's how we should do it. We haven't responded to this emergency motion because it's not an appropriate place to be talking about whether our summary judgment motion has merit. If they apparently have evidence they think is sufficient to oppose, let them oppose. If they feel like they need depositions, let them state why they need the deposition, what they expect to get, and why that would be relevant and material to summary judgment. They haven't done that. And this is just delay, delay, delay. That's all that's happening. And on the depositions, again, I'll say this, they've been talking about redeposing people since January and it's never happened. They've even attempted it.
Hold on a second. What's your position relative to the motion to amend the affirmative defenses?
Well, discovery's closed, Your Honor. They should have done it. They've had this information since February 24th at the very latest. And like I said, we produced these documents in a big batch in the fall of 19. And so I don't know we don't know when they actually knew about this information. You can't tell. We don't know.
Does the amended affirmative defense affect your pending motion for summary judgment?
No, it does not. It doesn't affect it because, once again, their theory all along was that there was this fee arrangement that tainted the process. Now they have a different theory.
Okay,
but that's fine.
So it doesn't sound like you have an objection really to the amended affirmative defense.
If I understand that the pleadings conform to the proof, so if they think they have proof that leads to some affirmative defense, that's fine. And if we think,
hold on a second, so we can take care of that at least. But I do think counsel's argument is well taken in terms of it's not an emergency, one. Two, you didn't submit hard copies of the courtesy copies. You emailed it, which is not proper pursuant to the current administrative order. And it was just by chance that I happened to see it in that email box, but that's not appropriate. Additionally, I don't see, while you make, I sympathize with the production of documents and perhaps some interruption in normal processes during the shutdown, but your motion doesn't comply with the requirements that you tell me what depositions you think you need and what information you think you're going to gain from those depositions. If I had that in here, supported by affidavit, you would have a stronger argument. But as it is presented to me this morning, I don't see a basis for delaying it. So if you want to, and which is what I told the counsel who appeared here on June 1st,
yes.
If you want to submit an appropriate motion supported by affidavit saying what discovery you need, what you think it will reveal that has bearing on the pending motion for summary judgment, I would consider that. But I don't see, just to say there's depositions without any frame whatsoever to support that, I can't stay the briefing schedule.
I understand, Your Honor. I know that the depositions are referenced in the motion, but I apologize for not properly submitting the submitting the courtesy copies to you in hard copy form and, not complying with your orders. But there is reference in the motion to the need to depose the board and the appraiser and the roofing contractor who are referenced in the documents. But if you need a more particularized showing on our part with an appropriate affidavit, we will then file that motion, and we'll file it shortly and ensure that it's ready to be presented at the status hearing on June 24th, if that is acceptable to Your Honor.
Okay, and the brief's not due before then?
No, Your Honor, the opposition's due July 1, and we would just ask that we have another round of motions before their opposition's actually due. I would ask that if they're going to make a particularized showing, they do that in their opposition on July 1.
No, I'm not going to do that. If he wants to file a motion, he can file a motion. I'm not going to enter an order barring the filing of a motion. So as it stands now, your motion for leave to amend your affirmative defense is granted. Your emergency motion to stay the briefing is denied without prejudice. You now know what it is, even though I told you the last time, what it is you need to do if you think you need to get relief from the current schedule. And it doesn't need to be filed as an emergency. You work on it and have it filed in a timely manner. If you want to have it filed next week, if you want to wait till the 26th, I'm not going to direct you one way or the other in that regard.
We will ensure it's a proper motion, Your Honor, before it is filed.
Your Honor, just pursuant to the local rules, since you found that this is not an emergency, we would seek leave to request our fees and expenses associated with this quote unquote emergency hearing.
That's absurd because the court has already granted our motion to amend the complaint. So we needed to have a hearing on that regardless.
It's not an emergency.
It wasn't necessarily an emergency. However, I'm not going to grant you leave. If you want to file a motion, then we'll talk about it then. But I'm not going to have that included in this morning's order.
Okay.
Your Honor, this is Jack Pryor. I just don't want to hide the ball and make sure we're on the same page. Obviously, the objection as to motion for leave to the affirmative defense is, however, I do want to apprise the court that as we see the affirmative defenses, it's likely we may file a motion to strike them just because they're boilerplate, not complying with fact pleading. So I just didn't want this to be, we come in, say one thing, and then there's a blind side of a potential motion.
Okay. So let's include in the order that the affirmative defenses will be on file within 7 days. I mean, I assume it can happen sooner than that. And then how long do you want to file a response to the affirmative defenses? Pardon?
I was talking to my co-counsel, didn't know his schedule either, so that's.
No, it's fine.
Okay. You want to just do 10 days?
Yeah, that works.
All right. I can reflect that in the order, Your Honor.
All right. So in the order for the 26th, we'll also set it for status of pleadings, but we may be seeing each other before then, it sounds like. All right. Anything else?
Nope. Thank you, Your Honor.
Right,
thank you, Your Honor. We'll get the orders exchanged.
Okay.
Have a good day.
Very good. You too. All right. I thought I saw plaintiff's counsel for Westberg versus Barcroft.
Yes, Your Honor, I apologize. Rakesh Khanna on behalf of the plaintiff.
Right.
Being late. Sorry about that. It just wasn't on my radar.
Okay. And then I had a brief, there you are.
Yep,
a brief,
right here.
Update in terms of Ms. Barcroft responded, it sounds like, correct?
Yeah. Yes, Your Honor. We answered plaintiff's complaint and answered plaintiff's written discovery.
All right. And then you also, plaintiff has a motion to allow alternative method of service. Is that right?
Yes, Your Honor, this is our second one. The first one you denied, so we went out and sent them again, and we found the wife again, and we saw cars that belonged to them, and this has just been a pattern and practice of theirs in a couple cases, so we're hoping to get them served by alternative service.
Okay, the only question I had is it was a little unclear. It seems like you know for sure where the wife lives, but then we have two separate addresses for potentially for Victor. It looks like 23340 North Old Barrington, and then also 425 Willow. Is that right?
Okay, so yeah, let me explain that. So originally they were living in the Barrington address. That property had been foreclosed. And so now they're at the Willow address. So they haven't been at the Barrington address. We thought they were, but that was foreclosed and now they're at the Willow address.
All right. So you want to serve by regular mail,
Yeah.
certified mail, and posting is what you're proposing?
Yes, that is what we're proposing.
All right, so I'll grant that request.
Great.
And then do we have any other dates in this case?
No, Your Honor, I don't believe we have any future dates currently.
Okay. So if I recall correctly, you said you are engaging in discovery, is that right?
Yeah, we're engaging in written discovery. We still have to issue written discovery. So I would just ask for time to do that.
Okay.
No objection.
Let's set it for status of pleadings and discovery, and that way we'll know if Victor's in the case or what the deal is with him. How about the week of August 10th? How do I look on the 14th?
I was just gonna say on June 12th, it looks like somebody set up a motion for 9 o'clock.
That's today.
Oh, that's it. I can't believe it's, oh my gosh. Sorry. I'm sorry, what date?
August 14th, but the 14th works for both of you, August 14th?
Yes.
I just want to make
Yes,
sure.
it works for plaintiffs.
That works for me, Your Honor.
All right, hold on one second.
Yeah, there's 5.
All right, so let's do 9:30 just for status.
That works. And Your Honor, it's Rakesh Khan again. Do you want us to prepare an order?
Yes, I definitely want an order. So,
Okay.
oh, you weren't here for my introductory remarks. So
Yeah, I'm sorry.
that's okay. So I want you to exchange it with opposing counsel before you email it, but it needs to be emailed to cc407@lakecountyil.gov. And that email address is also in our administrative order, which is online.
Okay.
So it's set for status on the 14th. If all parties are in agreement, you can submit an agreed order in advance of that date and strike that date. So, you know, if Mr. Barcroft appears and he wants time to file a response of pleading or whatever the case may be. Otherwise,
Sure.
I'll see everyone back here on the 14th.
Great.
All
Thank
right?
you, Your Honor.
Perfect. Thank you, Your Honor. Have a good day.
Bye-bye.
Thanks.
Thank you. Very good.
Keep Security Systems. George Street Acquisitions, 19 CH 626.
Good morning, Your Honor. James Sethna for the plaintiffs.
Carrie Conlon for the defendants.
All right. And it's defendant's motion to compel.
Yes, Your Honor.
All right, have you spoken?
We have went back and forth. Have we had a call? No, but I followed. We've been exchanging emails back and forth for quite some time now, since April. I referenced those dates in there.
So what I'm going to do is I'm going to put you in a breakout room, and I want you to see if you can resolve this on your own. And then when you have fully discussed it, you can come back. You just, at the bottom right, I think it says leave breakout room. You'll click that button and it'll bring you back to this main courtroom.
Okay.
So,
okay.
Hold on one second. All right, and then you'll get an invitation, like a little click thing that says, do you want to join the breakout room? And you have to accept that, and that'll send you there. All right.
Thank you, Judge.
Ms. Conlon, you're on here twice. I'm not quite sure why that is, but you'll.
Yeah, I couldn't get the audio to work on my computer. Maybe I can click out of the.
Well,
Yeah.
hopefully you'll be able to click them both to get both over there. There you go. All right. So we have Fawcett versus Walgreens.
Good morning, Your Honor. It's Robert Andelman for Walgreens.
Good morning.
Good morning, Your Honor. Michael Hillicky for Ms. Fawcett.
All right, good morning. So we have a number of motions up this morning, is that right?
Yes, Your
To
Honor.
Your Honor, we have the 3 motions that Walgreens has filed. That I can address them in whichever order the court prefers.
Okay, so what I do want to bring to your attention is that I received this morning the reply in support of the motion to stay, but I don't know if you can see it. It's all like torn up. I can't really like read it. It looks like maybe it got wet or something. So I didn't have an opportunity to read it. You went to the trouble to prepare it, so I would like to continue that motion to give it the appropriate consideration. But I have read the others. Well, I read everything other than that. So if I don't know if you want to file a reply in support of the other motions, or if you want to just go straight to those.
No, I mean, I think the other motions are pretty straightforward, Your Honor. The one that is easiest to deal with is the one involving the substitution of redacted exhibits on the prior pleadings that Walgreens filed, because the parties are actually in agreement on the result there. We just disagree about the why, and I think we each kind of staked out our positions about that, but the fact is we're in agreement about what should happen. So I think that's an easy one to deal with. The other issue on the protective order, also not very complicated. We basically agreed on the terms of a protective order. We both produced documents based on agreement to have it governed by the protective order, subject to the court's ruling on this one remaining issue. The one issue where we had disagreement had to do with whether Walgreens is obligated to retain a copy of all the confidential documents that are produced in the case, presumably by it, plaintiff, and third parties, for a period of 5 years after the termination of the case and all final appeals. From our perspective, that's not the norm. I've never actually entered a protective order that requires a 5-year retention period. We cited a number of cases in our motion where courts approved what I consider to be the normal protective order that has destruction at the end of the case. The federal standard, which the second district, since the 2014 amendments to 214, have directed us to, the Northern District of Illinois order, the standard order, has return or destruction at the end of the case. That is the norm. The federal regulations, although this case doesn't involve private health information, defines a qualified protective order as requiring return or destruction at the end of the case. And I think that's a recognition of the fact that, all data is vulnerable, no matter how many efforts we take to protect it. And so if you have confidential information, you use it for only the purposes of the case, and then you destroy or return it at the end of the case. The plaintiff's argument for why they need us to retain these documents for a 5-year period is that they are concerned about some unspecified risk of malpractice actions against them after the case is over. They don't say why they think they would be subject to a malpractice action. I kind of assume they don't think they're committing malpractice. They seem to be pretty diligent, competent lawyers. But in any event, the limitations period for malpractice action is 2 years. I'm not sure why we would be retaining it for 5 years, no matter what. I'm also don't think that the use of the confidential data in a separate malpractice case, even in a case within a case context, would be consistent with the terms of the order, which says that the information can only be used in the context of this very dispute. So I don't think that it makes sense to have that kind of retention at the end of the case. I noticed that although they provided a couple of examples where they got people to agree to do that, they haven't provided any court decisions where courts ever imposed it over the objection of the other side. And so we do object, but it's ultimately a decision that you need to make.
All right, response?
Sure, Your Honor. Well, number one, we've never had anyone oppose it or force us to come to court to argue about it. They agree to it routinely. So it's normal for us to have this information have this sort of provision in there. We're not asking Walgreens, we're not asking Walgreens to do anything. We're happy to hold on to the information ourselves. We simply offer that to them in case they're not comfortable with us holding on to it. And it's not a big burden. We're talking about data you can put on a flash drive and put in a drawer someplace. As far as 5 years goes, 2 years, 5 years, we picked 5 years because I believe there could be a tolling issue or something like that. So it could go, actually, the right to bring an action could go out 5 years. No, we're not worried. We're not necessarily worried about a malpractice action, but we do know that if we allow the case file to get destroyed, which is basically we're talking about almost every document they've produced. We allow it to get destroyed and there is an action and our insurance company says, well, give us all the information from the case file and we can't turn it over because we allowed it to get destroyed, then we've breached the cooperation clause and we've got a big problem with our insurance company. And we just can't agree to allow something like that happen.
Right,
So all the cases they cite, none of them deal with this issue, so they have nothing to do with this.
All right. I think that it would be inappropriate to and unwarranted to include a preservation language for 5 years in the order. So I'm granting, I guess, Walgreens' motion in that regard. All right.
Thank you, Your Honor.
And then let's talk about when we're going to come back for the other motion.
Yeah. And Your Honor, I can send him, I'm frustrated that UPS managed to mangle that for you. I apologize for that, but we'll send you a clean version.
All right, good. And then obviously I have the others. So we can come back fairly quickly if you would like, you know, even next week.
That would be great.
You want to do that? You want to do, how do I look on the 19th?
August 19th.
No, June.
There's 18.
Ooh, I don't want to do that. How about the 26th, the 25th or 26th?
26 is 15.
How about the 18th or 25th?
Is, I don't show anything on the 25th.
All right. Being reasonable. How about the June 25th?
Your Honor, I actually have, in the morning, I have a case set then. I don't know that it's going to happen because it's in the Daily Center. And even though it's still on the calendar, I think the Daily Center is closed, but I'm reluctant to schedule something in case it does go forward.
I appreciate that. What about the 24th?
24th at 6.
All right. Let's do, how about the 24th, June 24th? Does that work for you both?
That's fine with me.
All right.
Your Honor, if it's early, if it's like 9 a.m. like today, that's fine. We can do that.
All right. Let's do 9:15.
9:15 works too.
Yes, June 24th. And then just have a readable copy and we'll be set.
Okay.
All right. Anything else?
Your Honor, we would ask that the third parties who have received subpoenas be informed of the motion by plaintiff of the motion to stay and told that they can, you know, hold any production until the courts had an opportunity to rule on that.
Your Honor, we object to that. The third parties aren't complaining about the subpoenas. They're willing to comply with them. They're not here objecting. And the whole point of Walgreens' motion to stay is to, you know, eliminate some alleged burden on it, not third parties. So they don't have standing to represent the third parties in the motion. So if the third parties aren't complaining, they should comply.
Yeah, I don't want to stay it in the interim. I mean, my general impression is that I wouldn't stay it even after reading the reply, but I don't want to prejudge it until I've had an opportunity to read the reply. So in the meantime, the case will proceed.
Okay, thank you, Your Honor.
Thank you, Your Honor.
All right, you're welcome. And then submit that order.
Yes, we'll do that.
Thank you very much.
Thank you, Your Honor. Have a good day.
You too. All right. Keep Security Systems, 19 CH 424. Did I call Safeco Insurance? I think so. 20 CH 170. Is there any other case that's ready? I see a lot of people still out there. All right, so you're 19 CH 939. Oh, Schwartz versus Stone.
Correct.
All right.
Morning, council.
Morning, Judge.
All right, good morning. So I have had an opportunity to read the motion, the response, and the reply. If you'd like to make additional arguments, you may.
Good morning, Your Honor. Selwyn Skevin on behalf of the Stones. I just want to follow up with our, our motion to dismiss here on a few things. One, again, this is an overly verbose complaint that has 100+ allegations for what is essentially a request to return earnest money. It commingles many causes of action in each count. As far as the declaratory judgment goes, there's no cause of action for a declaratory judgment at this time because they've already terminated the contract. So if anything, they're looking to try and get damages if possible. But misrepresentations have nothing to do with the declaratory judgment. The violation of Section 25B of the residential real estate statute is not a declaratory judgment cause of action. And Section 45 of that also is not even a cause of action in its own right. As far as asking for rescission in counts 2 through 4, you can't rescind because a rescission is already a termination of the contract. And since they've already pleaded themselves out of court by stating that they've terminated the contract, they can't now ask to rescind it because once a door is closed, you can't close it any further. So that's another thing. And there's been an irrevocable change in the positions already because they terminated the contract. So if anything, what they're looking to maybe possibly get in terms of relief would be either specific performance or just simply an order by the court ordering the escrow agent to refund certain money. But that's not what's being pled here. As far as, and that's kind of the biggest thing is that you can't rescind something that's already been terminated, number one. And number two, they're combining and intertwining so many causes of action and so many allegations in every single count by not only restating and realleging. I mean, it's one thing to reallege your general allegations in each count. It's another thing to reallege counts 1 into counts 2, and then counts 1 and 2 into counts 3, and counts 1, 2, 3 and into 4. So that's another thing. And then as far as count 4 by itself, Section 45 is not actually a cause of action. It's not a standalone cause of action. All it says is that the statute does not prevent you from filing other causes of action. It is not actually a cause of action that is allowed.
Judge Rocky Hudson on behalf of the plaintiff. In our complaint, we have a right to tell our story. And if that takes 42 general allegations, then it takes 42 general allegations. He didn't set forth any case law that says that we're limited to a certain amount of paragraphs to state our case. As far as him saying that we are repetitious, I think I set forth numerous case law that shows that regardless of whether it's repetitive, superfluous, a surplus of allegations, the court can determine what's relevant and what's not relevant pursuant to that cause of action. That does not make the complaint itself defective. I set forth Childress versus State Farm Mutual Auto Insurance Company. It says superfluous allegation of complaint may be disregarded as surplusage. Environments of a complaint which are more as being immaterial or unnecessary do not affect the sufficiency of the pleading. We have a claim for declaratory judgment because there's an issue of who's entitled to the earnest money. We each have a tangible interest in that earnest money, and it's not actual controversy because we have a complaint on file and they have a counterclaim on file. I think we sufficiently pled our claim. As far as rescission, Judge, they're holding the money. There's not a specific performance because we said they committed fraud. They did not disclose the true condition of the backyard of the subject property. And therefore, we're trying to be placed in a position which we would have been if we never entered into the contract. It's a material issue. If they would have disclosed that, we would not have entered into the contract. I think if you review our complaint in detail, I think we've sufficiently pled each cause of action. And I'm asking for the court to deny their motion.
Did you want to reply?
Yes, please. Number one, holding the money. The escrow agent is holding the money. We cannot give something to them that we do not, that our clients do not have. Number one. Number two, the case law that he cites to in terms of we can tell our story and everything is from 1975. And it's not a matter of 40 allegations. It goes up to 110 allegations when clearly the statute says plain and concise statements of your cause of action. And then number two, the other thing is that in their arguments, basically, they are stating that they are trying, our clients try to induce his clients to act. Now, if you look at the actual agreement, the real estate contract, they submitted their contract and the offer before they received the disclosure statement. So they didn't act based on the disclosure statement. They just made the offer without any of that information. So they haven't really pled that they were induced to act if they submitted the contract prior to receiving what they're claiming are the material misrepresentations or omissions. So that kind of fails.
Judge, can I respond? I know he has the last word, but can I respond to that last position or?
Sure.
Okay, so obviously you have an attorney approval period and they didn't disclose it before the contract was entered. They didn't disclose it during the attorney approval. That there was snow on the ground when my clients looked at the property. They made no disclosure of that until after my client actually saw it and raised the issue to themselves. And as far as their issue with the section, I believe it was 45, I believe that's a valid claim. I mean, it states that they cannot use that statute as a means to shield them from disclosing material issues affecting the property. And I think they violated that.
All right, so my question to you is, on the residential real property disclosure report, what box should have been checked to say that there's a sewer drain or whatever in the backyard and the grass is difficult to grow?
Judge, the section states that you can disclose, it goes beyond that one page. You can add blank pages, you can specifically disclose that. The act says you have to disclose material issues affecting the property. And if it's not contained in that.
It's material defects.
Right, and we allege that there's a material defect because they resodded that area numerous times. It did not take effect. It's substantially unusable. They knew that. They disclosed it to us after we brought it to their attention that they made numerous attempts and each one failed. Now, the one page, they're not limited to that. The act doesn't say you just have to fill out this page. It says any additional information affecting the material issues affecting the property.
So in terms of count 4, that is not a standalone cause of action. The provision reads, this act is not intended to limit or modify any obligation to disclose created by any other statute. So you could claim, perhaps state a claim under another statute, when it says that, or that may exist at common law. So you state a claim pursuant to common law. You don't state a claim pursuant to section 45. So that is dismissed with prejudice. In terms of count,
I'm sorry, Judge. I don't mean to interrupt. I just wanted to know if I could respond to his, unless you want to just make the decision, which is fine.
respond to his what?
To his count. Yeah.
Okay, go ahead.
Sorry, I just wanted to say that actually the Real Estate Disclosure Act specifically limits all of the numbered boxes that you're supposed to check. There's nothing that says additional things. It does say if any of the above are marked not applicable or yes, explain here. But those boxes, there's nothing about a sewer drain, which number one, it's not like our clients installed the sewer drain. That's a village thing. And number two, to go house shopping in the winter, you're going to expect snow on the ground. You can't say, we need you to melt all the snow in your backyard to take a look, number one. And number two, they did also, they can't say that you have to wait until June or July so that we can see if grass grows. That's not really a material defect, like you said. So that's just what I wanted to say, is that whatever the material defects are in the statute, that's what you can only make a cause of action for, because it is limited to those. It's not anything else that a buyer may think is material. So that's all I wanted to say. Thank you.
All
He
right,
had
so-
actual knowledge.
Hold on. So I don't believe, that's my reading of the Real Estate Disclosure Act as well. Moreover, I don't think that there have been sufficient allegations of fraud alleged, even if I were to find somehow that violated the Disclosure Act. So for those reasons, I'm dismissing without prejudice the counts based on, so that would be what, 2 and 3, and count 1, I am denying the motion to dismiss. I do think that there is a dispute relative to the earnest money, and I think that a deck action may be the appropriate way to resolve it. I also think this sounds like a case that should be resolved.
Judge, just so I'm clear, because you said 2 and 3, but 2 and 3, 3 and 4 are the ones that deals with the statute. Count 2 is just rescission subject to common law fraud. So 1 and 2 is 1 and 2 is denied. 3 and 4 is granted without prejudice.
No, 2 is denied as well because I don't think you've sufficiently alleged fraud. So I'm sorry if I misspoke.
You said, so count 4 is dismissed with prejudice, 2 and 3 are dismissed without prejudice with leave to replead, and number 1 you're letting stand.
That is exactly correct.
Okay.
Is there anything else we need to discuss? Do we have another date in this case, Linda? So this is 20 CH 939. 19 CH.
So no new date.
Okay. So, I don't know how you're going to be able to state a claim for fraud. But are you intending to try to do so?
Judge, I would like time to amend the complaint, because if I don't bring a fraud count, I might bring another claim, whether it's a breach of contract or something to that effect.
Okay, so how long do you need to do that?
Can I have 28 days, Judge?
That would be fine. And then let's come back for status of pleading shortly thereafter. So that takes us to July 10th. How's my 17th? And then I have my date, the 17th of what? I'm sorry, July.
I have 6, 1 is at 9:30 and 1 is at 10.
All right, so let's do the 17th at 9. Work for you both?
Yes, Judge.
Yeah, that should be fine.
All right, and then, if there is an amended pleading on file and the parties agree that want to enter an agreed order in terms of responsive pleading or whatever, you can always submit that in advance.
Okay.
All right, is there anything else?
No, Judge.
All right.
One question, Judge, as far as submitting an order, is that emailed to you or is that something the clerk does? I haven't been in front of this court yet, so I don't know.
Mr. Hudson's already heard this several times.
Yeah.
Right.
I can,
so-
go ahead.
Yeah, so you'll find it in our administrative order, but what you need to do is prepare an order and submit it to our clerk's email box, which is cc407
Yes.
at lakecountyil.gov. I want the attorneys to both have a chance to look at it before you submit it in Word format, copy counsel of record, and it needs to be submitted by 1 o'clock today.
I will get on that right now.
All right, very good.
Rocky, I'll send it over to you.
All right, thank you, sir.
Sure. Thank you, Judge.
And then you're welcome. And then I have 19 CH 1019. Ms. Catone, you have your hand raised. So I can't hear you. I don't know if you're trying to speak. That's not even on my call. 10 or 19 CH 1019. Is that on my call sign? I don't see that it is.
1019.
19 CH, yeah, 1019.
I show that it is closed, it was stricken, and there was a dismiss with prejudice done on 6/10.
Okay, I don't know if she can hear us because I can't hear her. Maybe you can send her a message.
Okay.
Thank you. All right, and Mr. Cohen, 19 CH 608.
Yes, are we on your call today, Judge? Because there was some definite confusion on my end.
All
I
right.
received a postcard stating that it was today, and I looked online and it looks like our hearing is on June 26th.
All right, I don't show you on the call, but I'll have my clerk check. I see the number of the case, but what's the name of the case?
It is Nichols versus Schremer.
Yeah, that's definitely not up today.
That was stricken from today and it's on the 26th.
So it is,
Today's date was stricken and you're right, it is on the 26th.
I'd rather be here on a date that it was stricken than miss it.
That's
Thank
exactly right. All right, you're welcome. All right, and then we have the folks that are, oh, we have two people on. Is there any other case that needs to be called? I have two phone numbers out there, but I don't know what your case may be, so I will unmute you. Hello? The phone number 312 324 3557. Are you here on something?
No, ma'am. I'm just listening to, I'm with George Street as the plaintiff. I'm just listening in.
Oh, okay. And how about the 708 phone number? Are you here on a case?
I'm with George Street as well, just listening in.
Okay. And they are in the breakout room. I wonder if they know. Welcome back.
Good morning again, Judge. How are you?
All right. I'm hoping you're telling me you made significant progress.
Yes, actually, Judge, we did.
Good.
We went over all the different items, and I have a lot more kind of clarification now about kind of what's going on here. So we agreed that the plaintiffs will supplement, they'll provide some supplemental answers and a verification within 14 days. So we're not, I would say at this point, we would just really be withdrawing our motion because we're just doing that on agreement, if that would be okay.
Sure.
And then we were also discussing, because, you know, of course, we also have the status today about getting depositions scheduled. And we think that we plan to start depositions approximately July 1st. So council and I were just discussing, we're going to send each other some names of who we wanted to pose kind of in the first round and get those scheduled so that hopefully we could start the beginning of July getting people deposed. So I think actually, you know, we made some pretty good progress. And then part of my motion was actually getting responses to our second round of discovery, and I have that now.
Okay.
So that point's moot. So yeah, I'd just like to withdraw my motion. He's going to file some supplemental answers per agreement. That's really it from our conference, Your Honor.
Okay, well, good. I'm pleased to hear that. You wanted to say something?
Please, if I may, Judge. And council and I were thanked for the breakout session because we were able to kind of go over a lot. We are hopeful to start, like she said, doing depths. And between the two of us, I think we have about 30 potential witnesses, whether or not we need to call all of them. I just wanted to kind of point out to the court, if I could for a moment, in the responses we received from the defendants on interrogatories, this case, it relates to a real estate transaction about whether or not we can close on it. And the position they're taking now is somewhat contrary to what they took in their motion to dismiss, because they're acknowledging that they didn't terminate the contract. And from my perspective, my clients didn't terminate the contract. So before we spend thousands and thousands of dollars on discovery, I'm wondering if we have a valid enforced contract that hasn't been terminated by either side, shouldn't we just set a status about setting a closing date? Wouldn't that seem, in my opinion, and I know Carrie, you know, counsel's probably going to take a different position on this, but before we, you know, we dive headlong into a bunch of depositions to meet our January trial date, I just thought it might make sense to take a moment and think about that. If we are now in a position where the defendants are saying the contract wasn't terminated by them, then arguably the only thing they could do is say we terminated it. And if that's the case, then I would suggest that we focus all of our efforts on having the court resolve that singular issue, because our position is we didn't terminate it. And if they didn't terminate it, then it's let's close, because that's ultimately what my clients want to do. That's why they brought this lawsuit. They want to buy these buildings and pay the sellers the significant amount of money. So I just, you know, again, in an effort to kind of update the court, I know you.
Is this something you discussed?
Counsel and I we talked about this back in January, the last time we were actually in court with Your Honor. And at that time, I think the defendant's position was that they had some concern we didn't have the means in which to close. So we provided proof that our lender and investor are still on board, and they still are. So I just, you know, if there's a way to short circuit a lot of money being spent litigating something that doesn't need to be litigated, I would like to do that if we can. If that's not possible, then I understand, and that's unfortunate. And we'll move forward and take our depths and get ready for trial, you know, beginning of next year. But it's just something that, at least to put it out there so that it's in the ether, so to speak, so that the court and counsel and I are all at least somewhat on the same page in regards to that.
Okay, so it sounds like a discussion that you want to have further, and whether that, if you know, if you can come to some agreement in that regard, even better. If it means that somebody's filing a motion for a summary determination of an issue, you can, there are ways that you can address that. I'm not going to address it today when I don't have information.
Yeah, I am not asking you to rule that they have to go. I just wanted to get it out there, and so that it could be part of a discussion. I will follow up with counsel on that. I don't know if her clients have changed their position about objecting to a sale at this point or not. But again, if we're about to spend a significant amount of money on oral discovery, now would be the time to have that contemplation as opposed to later if possible. Your Honor, bring a motion if it is that singular issue. Sorry, Carrie, go ahead.
No, Your Honor, can I address this, please?
Sure.
This was never raised just now during our call, and it's really blindsiding me. I mean, this was not discussed. And to have a lengthy call about my motion to compel, and then for counsel to come back on the call and say, oh, well, actually, we don't need to do discovery. And he's making all of these accusations that are absolutely false in terms of my client's position in the case. My clients have always stated that his client terminated the contract in part by failing to pay the earnest money that was due. So I guess I just think this is really improper to be sort of arguing merits about the case and acting sort of like, well, we talked about this. We didn't talk about that. So I just wanted to make that point. And, so there's not going to be any agreement. Yes, we agree that they terminated the contract. There's nothing changed. So I don't know why that would change anything with respect to discovery. But yes, and he's also got claims against my client for fraud, for specific performance and for breach of contract. And we have counterclaims for breach of fiduciary duty, breach of contract, consumer fraud. So it's not as simple as I feel like counsel's sort of trying to portray it. So yeah, I would certainly, I'm not agree. I mean, if it's my choice, I'm not agreeable to delaying anything with respect to discovery. I mean, they just sent me a second round of discovery a couple of days ago. And if that was the case that, oh, this was just so easy to resolve, I don't know why I'm being served with all this additional discovery. So. Okay.
So as I said, it seems like something that you would have discussed in the breakout room. It seems like something you can still discuss. If the party's position is, we want to sell and we want to buy, it just fell apart earlier, let's get together and resolve this. You obviously can do that. I'm not going to enter an order limiting discovery. If somebody wants to file a motion, like I said, I would encourage the parties to talk. Seems like you made a lot of progress when you did this morning. And I know it was just on the limited issue relative to discovery, but if both parties are motivated to resolve it, or if you want the court's help in that regard, you can always address that at the appropriate time. But for now, you'll withdraw your motion and let's set it for a status then. You said you're expecting, absent some kind of an agreement otherwise or resolution of the case, which would be ideal, but you're talking about starting discovery and a coordinated effort to do that, oral discovery. And so what makes sense in terms of a date before we get too far down the line to make sure we're on track and that whether any dates need to be modified? Do you have a proposal?
I would suggest maybe like the first week of August, early August, just to kind of see where we're at, Your Honor.
Okay. I have several trials back to back, so my request would be that we go at least into the week of the 10th.
Okay.
So how about, did you say, Linda, I look okay on the 14th?
Which month?
I'm sorry, August.
There is 5.
All right. 9. How about that? How about August 14th at 5? Right, 5, excuse me, at 9.
That's fine, Your Honor. Thank you.
All right. Does that work for you as well? counsel?
Yes, Your Honor, and I'm presuming this is going to be a Zoom call unless we hear otherwise?
Right, I mean, check for an administrative order. You know, they come out periodically. I don't know what phase we'll be in and what that means for our courtroom. I do know they did some study, and by the time, if you had the appropriate social distancing, only like 3 people could be in the courtroom. So we have some work to do before we get there, but yes.
And then just one last matter with regard to the order that counsel and I will craft together, then 14 days for me to supplement our initial round to kind of address what she and I spoke about in the breakout room. Or do you want everything laid out in there in the order?
Maybe I misunderstood this comment. I thought you were withdrawing your motion. So the only order today would be the motion was withdrawn and we're continuing the matter to August 14th. Did I misunderstand?
I think we were also yes, withdrawing my motion, but with the order indicating that by agreement of the parties, council would supplement within 14 days.
Okay, that's fine. Is that your understanding then? Apparently I was the only one who did not understand.
We apologize for not making that clear from the outset.
No, I'm sure on my end. So that gives you until the 26th then, right?
Please.
All right. Anything else that we need to include in the order or address today?
I don't have anything else, Your Honor.
All right. So Ms. Conlon, I think you've been on the call the whole time, but submit the order to my CC 407, or not my clerk's CC 407 at lakecountyil.gov email box.
Okay.
Parties exchange in advance, so there's no misunderstanding, and a copy council record when it's submitted.
Of course. Okay. Thanks, George.
Okay.
Very good.
Thank you again for your patience. Thanks, Carrie. Have a good day, everyone.
Bye. Okay. Bye.